There is a lot of confusion surrounding resolution meetings for parents in New York City, and it's not surprising. Though seemingly relatively simple, resolution meetings can be surprisingly tricky. Today, I'm going to demystify resolution meetings for parents in New York City. Before I say any more, I want to share a disclaimer. Although the videos on my channel pertain to special education law in the state of New York, resolution meetings are handled so differently within New York City that it is necessary for me to do this video specifically for New York City parents only. Again, resolution meetings are handled much differently outside the 5 boroughs, and this video is only for parents who are suing the New York City Department of Education. For parents outside the city, resolution meetings can actually be very helpful, and sometimes they can jumpstart the settlement process. Because it is common for parents and attorneys to attend resolution meetings in person together outside the city, parents should consult with their individual attorneys prior to the resolution meeting regarding what strategy to take at the meeting. As for all my New York City parents, the following is for you. This is the harsh truth. Though the New York City Department of Education is required by law to hold a resolution meeting within 15 days of a case being filed, most parents' claims cannot be resolved through resolution. Also, while parents who do not believe their claims can be resolved in resolution can opt to waive their resolution meeting, the DOE must agree to waive the meeting as well, and they do not always do so. So if the district wants to go forward with the meeting, the parent must participate. Failure to do so could result in a reduction of the parent's award at hearing. If you have to participate in a resolution meeting, I have the following 6 important points for you to keep in mind. Number 1, the DOE representative on the other end of the line cannot resolve reimbursement claims, and he or she will often tell you that right away. It is for this reason that most parents and their attorneys can conduct resolution meetings with the DOE over the phone, and that they are very short, oftentimes not more than 5 minutes. Remember, if your case is not resolved at resolution, it will just get moved over to the Office of Legal Services to be evaluated for a possible settlement. Just because it can't be resolved at resolution does not mean that it won't be settled. Number 2. If your child is attending an approved non-public school, funding cannot be granted at a resolution meeting, but a new IEP meeting can, at which funding can be considered. The DOE can also reconvene an IEP meeting for other reasons, order evaluations, and issue RSAs, which are vouchers for related services. If you are seeking any of these, a resolution meeting can be useful. Number 3, if you stand to gain something from the meeting, your attorney may very well advise that both they and you attend the meeting in person. This type of strategy should be discussed with your attorney on a case-by-case basis. Number 4, you can agree to a partial resolution of your claims at the meeting and move forward to a hearing or settlement on the other pieces of your case. Number 5, if you are offered something at resolution, you should keep an open mind, but tell the DOE that you need to see any offer in writing first before you can agree. Number 6, finally, if you have an attorney, they will be with you either on the phone or in person. Let them lead the way. Often resolution is a formality and the parent will not even have to speak at all. As you can see, resolution meetings are not necessarily straightforward, and the manner in which they are handled often depends on the individual facts of your case. One last thing to keep in mind. Anything that you say in a resolution meeting can later be brought up at a subsequent hearing. So unless you are very confident about your case's likelihood to be resolved, if you are at this point in the litigation process, it's probably a good idea to consult with an attorney. If you have any questions about this, please don't hesitate to reach out to us at jennifer@ratcliffelaw.org or at 646-741-3030. We look forward to hearing from you.